Good evening, this is Rahul Reddy live here from Houston, Texas. Reddy Neumann PC does bring immigration news every week Tuesday at 5 p.m. Central Time. Along with me is my business partner, Emily Neumann. Emily, now there is a lot of media things that are going on that if a person falls out of status, he loses a job, you are allowed to stay in this country for 180 days. We already know that on the H-1B, if somebody loses a job, they're allowed to stay up to 60 days when the I-94 is valid. Did they extend it to 180 days?
No, they haven't. And there's been a lot of misinterpretation in the media since yesterday. USCIS made an announcement that really was not an announcement because all they did was reiterate what the current law is. They did not provide any new benefits or new extensions.
If the current law does allow only 60 days, when they reiterated that, how did it turn out to be 240 days? I'm sorry, not 180 days, 240 days in the media.
Yeah, they're relying on the 240-day rule and saying that you can, once an extension is filed, you can stay for 240 days, not just 60 days. And that's just not true because the 240-day extension is for extensions of stay with the same employer, where if you've timely filed it, you can continue working for up to 240 days beyond the I-94 expiration based on the pending extension.
So if it's been denied, they cannot work?
Correct. And if your I-94 has expired, which that's the whole purpose of the 240-day rule, there is no 60-day grace period. So I don't know where they're coming up with that. It's completely misinterpreting what the current regulations are and also what USCIS said yesterday. They did not provide any kind of extra or new extension for people who lose their jobs.
Sandeep has this right question on YouTube right now is that if the H-1B person is laid off and within the I-94, his I-94 is still valid, can the H-4 EAD continue working for the next 60 days?
Oh, good question. I don't think so because
I may want to disagree with you. Here is the reason why I may want to disagree with you is that the 60-day period, he's maintaining the legal status, his I-94 is valid.
That's only if a transfer is actually filed.
No. In this case, if he got laid off, he has 60 days to file for the transfer, is that right? So does it mean that he's not maintaining the status of the? It means that he's maintaining the status for the 60 days.
Only if the transfer is filed within the 60 days, then it's as if he never fell out of status.
Okay. Is there any law right now that has been given that when the H-4 EAD extension expires, can the person continue working for a period of time? Did the USCIS give anything like that?
No, not at all.
Well, where are all these rumors coming up, Emily?
I think it's media trying to get clicks on the internet. That's my best guess. Fake news. It's completely incorrect.
Okay. Any other incorrect news that you're looking into the media right now that?
I think that we see a lot of F1 applicants or F1 individuals who think that they are allowed to apply for an EAD simply because of the pandemic, and that's completely false. There's no special EAD for that. I think that there is a thought that it's okay to just stay because there's a pandemic and because they're not able to leave, that not filing is just, it's okay to not file, and that's not correct. I also see people, I know I forgot the third one, sorry.
Yeah, a lot of people are on the mistaken assumption that if your B-2 is expiring, you can stay unlawfully in this country. You cannot stay after the I-94 expired. This is a misconception. There is an online application called I-539. You could file the online application at I-539 and continue staying. I mean, you don't have a problem. You can file it online. It's not that you have to go anywhere to a lawyer or you just file it online. So please don't be under the misconception that any rules of regulations have changed. Emily, there are some things that things have changed. Can you tell what things have changed right now after this COVID situation came out?
Yes, so if you have a request for evidence or a notice of intent to deny, notice of intent to revoke, or a denial where you're filing an appeal that was issued between March 1st and May 1st, you're given an extra 60 days to respond to that RFE. That's really the only change that has happened. Other than that, the only other change is a negative change in that they got rid of premium processing.
Which is bad, actually.
Yeah.
Emily, what about the H-1B lottery cases that we are filing, that we've been selected in the lottery? Is there any delay in issuing the receipt notices?
Yeah, so USCIS also came out yesterday and said that they are going to delay the data entry of those cases, which also means the receipt notices will be delayed until at least May 1st. So you were able to file beginning on April 1st. And you have until June 30th to file. But if you're filing between April 1st and April 30th, know that they're not even going to start data entering your petition until May 1st, and only then will they issue receipts. So if you've already filed, it's very likely that you won't get your receipt until mid-May at the earliest, even though you filed early.
Emily, there are some H-1Bs that have been denied by the USCIS by mistake in the lottery system. Is there any way USCIS is going to correct it? How is it going to occur now?
Yeah, so
when
initially,
we find out it's 900 cases.
Right. Initially, attorneys were reporting that they, instead of showing either submitted or selected in their online portal, it's showing denied. And that seemed to be an error because you only get a denial if you have a duplicate entry, and these attorneys are saying there's no duplicate entry. So they brought this to the attention of AILA, the American Immigration Lawyers Association, who brought it up to USCIS. USCIS came back and said, actually, it appears that it's operator error or user error in how the registrations were submitted in the system. It's not a USCIS error. Then they said, actually, it's 900 cases that are like that where the registration was denied, and USCIS is saying it was a proper denial. So those people are unfortunately out of luck. They're not going to be changing their mind on that for those people that got the denial notice.
Emily, on the COVID situation, there's a rumor that the Vermont Service Center had some people who had a COVID. What's going on? Are they going to?
Yeah, on Friday, they said that they were going to stop allowing mail to come into the Vermont Service Center because they had some employees that they thought were, had tested positive. So they were going to not accept any mail at the Vermont Service Center until tomorrow. But then today they came out and said, never mind, the test came back negative for everyone who's involved. So they've reopened the Vermont Service Center and they are accepting mail. So there shouldn't be any issues with filing if you have to file at the Vermont Service Center right now.
I'm a bit worried about your statement, Emily. There are 600,000 people that are tested positive in the United States right now. And every day there's 20 to 40,000, 20 to 35,000 people are getting positive in it. You mean to say if somebody is tested out of the 500 or 1,000 people that are working there, they're going to close the entire thing out?
That seems to be what they thought they were going to do last week, so that they could clean everything and then bring everybody back this week. But
so we want you guys to be updated on the immigration news. We'll bring it every week, so please check with us every week at this time, every Tuesday at 5 o'clock. The situation definitely is worse. My own brother-in-law, the entire family got the COVID. His wife is one of the kids, and two of the kids didn't get it, but they got it. They got tested late, and by the time they got tested, they're almost done with their course. I mean, the virus is just disappearing anyway. The good thing is that they are fine, but I'm expecting that it's going to, things are going to spread out when there are 1,000+ people working in a service center, and if they're just one person who gets it, most of the healthcare workers are getting anyway. So there should be some changes expected, Emily, that I'm thinking about the USCIS. Even if they test positive, they can't just stop the entire mail for thousands and thousands of people getting in there. And especially the problem is if they stop the mail, what is going to happen? What is the USCIS going to do it? Send it back to us? Would they destroy it? What is going to happen to the mail and deadline? We will keep you updated. At this point of time, all service centers are accepting the mail, except that there's one delay that happened, but they are now accepting. We don't know yet if there is anybody who tested positive, whether they're going to pause it for a while. At this point of time, nothing is there, but please keep tuned for the next week, how the things are going to turn out to be. Emily, now there is a lot of things, with the COVID situations are bad in the country. Just like the US workers, the H-1B people are also prone to get furlough. Is that allowed? We know furlough is allowed for the U.S. workers, but what about the H-1B and L-1, E-3 visas and E-2 visas, though?
Right, it's not allowed. So specifically for H-1 and E-3, where you have that LCA requirement, the employer is not allowed to bench someone without pay, which is basically what a furlough is.
What would I do if I get furlough right now?
You should assume that your 60-day grace period has begun on the day that the furlough begins, and start looking for either finding a new employer to file a transfer or filing a change of status to any other type of visa that you qualify for. If you don't have an H-4 as an option, probably plan to file a B-2 within 60 days of the furlough.
Is the reduction in the pay or reduction in the hours allowed?
A reduction in pay or hours may be allowed if a new LCA is obtained and an amended petition is filed, but without actually filing something, a reduction of pay and a reduction of hours would both be considered a material change in employment, and you can only move forward with a material change if an amended petition is filed. So if nothing's been filed, that can be considered a violation of status.
How about working from home? If the employee's home falls within the same MSA and drivable distance from the clients or his employers where he's working at, is it allowed?
Yeah, that's the one area where we do have some flexibility in being able to work from home because the LCA covers that area. It's not considered a material change, so nothing needs to be filed. So that is one blessing here where everyone's stuck working from home.
What if the person is working at a distant location? Let's say the employer or the client location is in New York and his home is in California. Can he work from California, and how long can he work? What are the regulations on that?
So the short-term placement provision may allow that person to work from the other location without having to file a new LCA or amendment, but that's only for up to 30 to 60 days in a one-year period, and very specific requirements have to be met for that. So if it's going to be for longer than that 30 or 60-day period, then a new LCA and amendment would need to be filed.
Can the H-1B employee be laid off under this situation?
Yeah, I mean, it's definitely possible. If that's the situation, it's going to be treated as a termination of employment. And so then if your I-94 is valid, you have the 60-day grace period to file a transfer or a change of status.
Lots of questions are coming up. We will answer as much as possible. We would request all the people who are trying to answer the questions for us, please refrain. We are licensed lawyers. We have a little bit more experience in it. We recommend that you do not answer each other's questions. If you want, you can come to our daily conference calls. If we are unable to answer, please don't try to answer the question. One question is from Sam from YouTube, is that he's an H-1B. Is he eligible for the coronavirus stimulus check? He's speaking about the $1,400 to $2,800 return check that is coming. That is a tax. The tax that you paid is returned to you by the IRS. You are definitely eligible. We do not see any problem whatsoever at all. Sripad Sai has his question. He's on STEM extension and he filed the income tax returns. Is he allowed for the stimulus check? We don't see any problem whatsoever at all in you getting the stimulus check and cashing it, and it should not cause any problem in you getting H-1B or any other visa. Do you see any problem in that end?
The only issue would be if he's filing taxes as a non-resident because he's a student, then you're not eligible for it.
Oh, okay.
So if you are a resident for tax purposes and you have a social security number, not an ITIN, then you're eligible.
But in the case of the OPT and STEM extension, they file as a non-resident. They don't pay social security. They are not eligible.
Correct.
So I thank you for correcting me. So H-1B is eligible. Mm-hmm. Okay.
Yeah, one other thing on that to be aware of is if you have kind of a mixed status in your house where maybe you filed as a resident and you have your social security number, you're an H-1B holder, but your H-4 spouse is not working, didn't have an EAD, so filed using an ITIN, the whole family is going to miss out.
Oh, really?
Yes, that's what happened in the 2009 stimulus, and that appears to be the case of how they're handling it now. Same thing if you filed as a whole family, but your kids have the ITIN number versus a social security number, you're not able to get it.
Ah, okay. So let me understand. If the H-1B and H-4, both of them have the social security number, they will be able to obtain, what if the H-4 has not worked at all, but has a social security number? Can they still get the stimulus check?
I believe so. I think it's all based on what you listed on your tax return. Is it married filing jointly where both spouses listed social security numbers? Then you should be able to get it, assuming you filed as a resident. But otherwise, if
most of the people will file as a resident. I'm a bit worried. Most of the people that I came across, they're all filed as a resident. The only people
other than the F1.
Other than the F1s, yeah. So F1s, F2s, and if they get F1s who get their things, they should not cash the check then.
If they're a non-resident.
Yeah, most of the people of the F1s file as a non-resident, and most of the people who are the H-1B files as a residents to my knowledge. But if you do otherwise, please check with your CPA on that thing. Vamshi has this question: can the H-1B, if the employer has reduced hours for less than 40 hours and is paying less money, will it cause any problem? Yes, it will cause problem. You may have to file the amendment. Amendment may be required. If the amendment has not been filed, you may have violated the legal status and you're counting the 60 days.
All right. Joel from YouTube says his wife got selected in the lottery from last year and her case is still pending. But even if she gets an approval now, how can she start working without a driver's license and social security number? So the social security number is not needed for employment authorization for I-9 purposes. So the H-1B approval notice plus the passport is considered a proper I-9 document to show that she's authorized to work. Where the social security number becomes an issue is if the company is an E-Verify company, they'll have to delay submitting the E-Verify until the social security number comes in. But she's still authorized to work even without that. Now the driver's license, she may have to take an Uber to be able to get to work, so she doesn't work without, drive without having a license unless you're in a state where the driver's licenses have been automatically extended during this period.
Alok has this interesting question. He's an H-1B. He has an option of a L2 EAD option. Can he do the automatic revalidation by going to Mexico and coming back? And can he apply for the unemployment benefits? Emily?
I'm sorry, I missed the question.
No, that's okay. I don't see any problem, Alok, for you to do the automatic revalidation into L2 plus EAD. I don't see any problem in you applying for the unemployment benefits either. We want to reiterate one more time. The people on L2 EADs, the people who are on H4 EADs, they can avail the opportunity of the unemployment benefits. There are a lot of questions that came out when our business partner, head of the department, V. Hong, wrote an article that the H4 EADs and L2 EADs can claim the unemployment benefit. She has clearly mentioned in her article at rnlawgroup.com, which we republicized it with giving more details, is that the public charge, the unemployment benefits are not included in the public charge at this point of time. So we don't see any problem for the H4 EADs and L2 EADs to apply for the unemployment benefits. Now, the H1s, the L1 visa people, and also the E3 visa people cannot apply for the unemployment benefits. The main reason is that for you to apply for the unemployment benefits, you must have an unrestricted, valid employment authorization. H-1B only allows you to work for a particular, H-1B, L1 and E3 are only allows you to work for a particular company for a particular position. So you are not eligible for the unemployment benefits. We don't see any problem for L2 EADs and H4 EADs. If their employment authorization is valid, they can apply for unemployment benefits to their state. We don't see any problem in it.
Tejaswi from YouTube says the H-1B got picked, and this was the last attempt while I'm on STEM OPT, but now I lost my job. Can I be on CAPGAP? So it's really important for this year to understand that just having the registration selected is not enough to get the CAPGAP extension. You need to also have your company file the H-1B petition on your behalf. And if it's timely filed before your OPT expires, requesting a change of status with an October 1st start date, then you are eligible for the CAPGAP. But if you lost your job and the employer's not filing the H-1B, unfortunately there is no CAPGAP this year. Natasha from Facebook wants to know, is the news correct that USCIS has agreed for automatic approval for a year or 240 days for all pending H-1B cases, which includes RFEs as well? No, that is absolutely not correct. There's no automatic extension of anything. Nothing has been extended for 240 days. There's no 8-month extension. All the rules that were already there before COVID-19 are the same rules that are in place. The only thing that has changed is no premium processing and an extra 60 days to respond to an RFE if it was issued between March 1st and May 1st. That's it.
Money from YouTube has this question. If you accept the stimulus check, will it be considered as a public charge? If you are eligible for the if you're eligible for the stimulus check, we covered that in the early part of our presentation. No, you are not considered to be a public charge. Absolutely not.
Karnam from YouTube wants to know, any idea when premium processing would start again? Well, this is a different kind of premium processing suspension than we've ever had before. In the past, whenever they've suspended premium processing, it was usually for cap cases because of the high volume of filing, or it was because there were a large number of filings that created a long backlog for those that were reaching the 240-day limit. So usually it's a volume issue as to why they suspend premium processing. This time around, it's more of a workload issue from the officer's perspective that if they have people out sick, they have people working from home, they have people that have kids that aren't able to work a full day like they normally could, they don't have enough manpower to ensure that they can meet the 15-day processing time. So until the government and the states and the economy kind of reopens and everybody's able to get back to work, I think the premium processing suspension will continue. Hopefully once everybody goes back to work and back to normal, it should reopen relatively quickly, not for the cap cases, but for the I-140s and the regular I-129 petitions.
Vimal from Facebook has this question. Getting maxed out, not able to travel due to ban, what would be the advice? File a B2 application. Absolutely, you can do it online and you will be considered to be in a period of authorized stay. So I don't see any problem in you doing it. Please file it. Don't let the I-94 expires. Supriya from YouTube has this question. My passport expires this year in October. I'm applying for the H-1B renewal. Will the renewal have renewal of the H-1B validity has anything to do with the passport validity? To file the renewal, Supriya, your passport should be valid on the day you're filing the application. It doesn't have to be valid until the expiration of the H-1B. So it should not be a concern at all for you to get the H-1B extension. There are some issues where people, when they are traveling from their home country to the United States, they may be restricted to give the I-94 validity until the expiration of the passport. But in your case, when you're filing within the United States, we do not see any problem whatsoever at all. Avinash from YouTube has this question. He got laid off. He's a green card holder. He got the green card in January of 2010. Will it be any consequences for his green card, or will it be any consequences for him to get the citizenship? Absolutely not. You should be fine. This happens. Sky fell down and you lost the job. Nothing wrong with it. You can even apply for the unemployment benefits. It should not impact on your GC or in your naturalization when the time comes.
Pranitha from Facebook wants to know, if an H-1B transfer is still pending, can we work for 2 employers at the same time, the current employer and the new employer, based on the receipt notice? The answer is no. The only time you can work for 2 employers at the same time is if the H-1B is filed for concurrent employment, meaning working for 2 employers at once. If it's a transfer, you have to pick one or the other.
I get these questions, when would the consulates be open? And then also I got the question here, when would the Indian consulate will be open in Houston, Texas? These are judgments we cannot make. I have only 25 years of experience in immigration. That seems to be very short, especially under these circumstances. I have never come across this kind of situation in my 25 years of experience. So you will have to, unfortunately, with my limited experience, you will have to keep coming every week and we will update you. But at this point of time, I cannot predict how the things are going to work out.
Arun from Facebook said his employer received an email approval for an H-1B, but it's only valid for 20 days. He wants to know, is there a history of mistakes happening in these email notifications, and what is the best course of action? So it's pretty rare for the email notification to have a mistake compared to what's on the approval notice. So either there was a mistake in the approval notice that issued it for a shorter period of time than what you're eligible for, or it was cut short due to an end client letter or a work order or something like that. We do see shortened H-1B approvals quite often. As far as the best course of action, it really depends on the circumstances and why it was cut short. Litigation may be an option. Right now, the difficulty is, unless it was a premium processing case, you have the option, the employer has the option of emailing premium processing, but they're taking several days to get back. So if you don't hear back and there's nothing resolved by the time this 20-day period is ending, your employer may have to file another extension so you can keep working.
Are there any expected delays in the labor certification process? We are not expecting the labor certification to be much delayed. One reason is that labor application was always online, and most of these officers were working from the home before anything like this happened. And I've noticed that even in our office, where people are working from home, they requested a lot of leaves and they canceled all the leaves. And I said, one reason is that they couldn't go anywhere. Where are they going to go? They took a leave to go to the marriage functions. They canceled all the leaves and working. So the Department of Labor we haven't seen any delay, but you never know how it's going to work out. Keep tuned in. But as of now, we are not noticing any delay.
Sona from YouTube started working for Company B on the receipt notice, and after 2 weeks decided to go back to Company A because they never terminated the H-1B petition, and wants to know if that will create any issues when filing the DS-160. So there's no issues with that. Once you file the transfer, you're eligible to work for the new employer based on the receipt, and that old employer's petition becomes a dormant H-1B approval. It doesn't go away. That approval remains valid until it either expires or withdrawn. So if it never expired and the employer did not withdraw it, you're allowed to go back to that company. When you're filling out the DS-160, though, you need to make sure that you do list the 2 weeks that you worked with the other employer. Don't make it appear as if you worked for the same employer the whole time.
Sandeep has a question. He got laid off on H-1B. He wants to file a B-2. Can it be filed online? Does it need a lawyer? Yes, it could be filed online. It's called I-539. We do have a special discount right now because of the filing process where, you sending the application here, we processing and everything. We can guide you on the phone if you make an appointment directly, and we even discounted our consulting fees. Whatever the normal fees we charge, we are charging 50% less than what we used to charge until the April 30th because of the COVID situation. So if you want to use that, you can make an appointment with me, Emily, or anybody else, and we can guide you in getting that thing done online while you're on the phone.
VJ from Facebook has a valid H-4 and H-4 EAD till December of 2021, but is currently in H-1B status and wants to know if he files a change of status from H-1B to H-4, can he start working using the H-4 EAD while it's pending? Unfortunately, the answer is no. You have to be in H-4 status in order for that EAD to be considered valid. So just filing the change of status from H-1 to H-4 does not automatically put you in H-4 status. You're then in a period of authorized stay, but you have to wait for the H-4 approval before you can start using that EAD again.
Lakshmi from YouTube has this question, H-4 to F-1 age out, is there any chance to use the biometric done for the H-4 extensions for the F-1? At this point of time, there's no clear guidelines from the USCIS. They did exempted certain people from the biometric requirements, but it does not the H-4 to F-1. It still is a requirement. There is a federal court litigation filed last Friday by Reddy Neumann PC challenging why they need these biometrics. Every time we file an application, we'll have to see the outcome of that litigation. It's part of the H-4 EAD delay litigation because now there's no biometrics done. We want these H-4 EADs to be approved. So H-4s and H-4 EADs approved. So we challenge the decision of the USCIS why they need the biometrics. We'll have to see how the court is going to act on it.
Srinivas from YouTube recently got his EB1 I-140 approval, congrats on that, and has filed the 485 application last week. He wants to know when he can expect the receipt and when he can expect the EAD. So as of this moment, I have not really seen any delays in getting the receipt notices, so I would expect you should be able to get it within about 2 weeks. And the EAD can take anywhere from 4 to 5 months right now, although I will say I had one recently that got approved in only 2 months, very recently. So they're all across the board, depends on which service center is at, but I would plan on 4 months right now.
Chakra has this question, is there a chance that USCIS is going to conduct the lottery this year again for the H-1Bs that have been selected and not used up? Chaitra, it's very hard to guess that one. We're expecting anywhere between 1 to 3% of the people might be selected in the lottery because of less filing. That's just our guess at this point of time. They may have already accumulated, accepted more than what they are going to, more than 85,000. They might have some reserved too. But if you are planning your life, I would recommend that if I were you, I would assume that it's not going to be selected and then try to plan my life accordingly.
Supriya from YouTube has a passport that's expiring in October, and
I covered it.
Oh, okay. Let's see here. San from YouTube wants to know if an H-1B can move to F2 status and then come back to H-1B without going out of the U.S. So technically, yes, you can file a change of status from H-1B to F2. Just know that the processing time could be anywhere from 8 to 12 to even longer months to get the F2 approved. So the F1 for the spouse must continue to be maintaining status and be valid the whole time you're waiting for the F2 to be approved. And then later you can file a change of status back from F2 to H1, but you need to know that you can't begin working in H1 status until the H1 is actually approved.
Question is that rumor mill, Avinash is asking this question from YouTube that they are going to waive the requirement for the interview for the adjustment of status. As you stated, it's a rumor. I completely agree with it, and let's state we have no concrete evidence that those things will be done. This is very premature at this point of time to think that the whole world is going to move into remote operations. At this point of time, I don't think so that is going to happen. Adjustment of status interview waiver didn't used to be there when in 1993 to up to about 2000 or so, there was no interview waiver. After that, they started waiving the interview, but the interview waiver has been taken off in 2017. I don't think so this administration intends to have an interview waiver for the adjustment of status. Also, a lot of people ask that, when it is a recession period, will the USCIS and the immigration will be more lenient? I have lived as an immigration lawyer in United States, 2 recessions. The other recession, I was just, here when the recession was just getting out of it. The previous two recessions, 2000, 2001, in 2008 and 2009, the USCIS was more stricter, more harder, more harsher than any other time dealing with the non-immigrant visa people. So don't expect any leniency. Now when it comes to the depression though, era, that was between 2018, 2020, 2030, I don't want to go into that details and scare you guys at this point of time. That is a really scary thing. So I will leave it. The depression period also, it's going to be more stricter enforcement rather than lenient. So don't expect any good thing coming out if the recession. Hopefully the economy picks up, everything picks very good, so everybody will be fine. If not, just like all Americans, we will also have a harder time. We will face much harder time than the American workers, so be prepared for it.
Sandisha from Facebook wants to know if the H-1B lottery status says submitted, does that mean you were not selected in the lottery? That is correct. As of this moment, those that were selected will say selected in the online system. If it's still showing as submitted, that means it was not selected in this go-around, and there may be another go-around. We don't know what the future holds at this point because everything is so uncertain, but if there's another go-around and yours is showing submitted, then you would be included in that next lottery. But at this moment, for this lottery, it means you're not selected.
Krishna has this question from Facebook. If a person changes to H1 to B1 visa, can he change from B2 to H1B back when the job market is stable? Ideally, what you're speaking could be achieved, but practically it's almost impossible. One of the main reasons is that by the time the B2 is adjudicated, it may be 7 or 8 months. You can only request for a 6 months B2 extension, and by the time they rule the B2, it will be 7 months. In other words, you have to file one more extension. And the problem is that while the B2 is pending, if you file a H-1B application, assuming even if the premium processing is going to be back, what the H-1B USCIS officer will ask is that the bridge application of the B2 is not approved. So I'm not going to approve this H-1B with the I-94. So a lot of time when people are in this situation as an immigration lawyers, what we choose to do it is that instead of going for a change of status from B2 to H-1B, we directly go to the consular processing. That is much faster than waiting for the B2 to be adjudicated, which may sometimes even take multiple B2s and maybe a year or so. So it is not practical, Krishna, to move back from B2 to H-1B. The best idea that I would suggest you, Krishna, is that if you are on H-1B and you lose the job, it's a good idea to file a B2 because there is no flights going to your home country at this point of time. File the B2, but pre-plan to leave the country and come back when your job market is high and have a company file for H-1B and come back at that point of time.
Maheshwar from Facebook wants to know if a person is laid off while on H-1B but not actually terminated by the employer, they never sent a notice to USCIS of the termination, they never offered to pay the return transportation to their home country, and the employer now wants to bring the person back after a few weeks. Can they just start working again? What should the employee do? Well, the failure to pay is a violation of the LCA rules by the employer, and that is likely to be seen as putting you out of status. So if the employer wants to bring you back and they did not withdraw, I think you would need to travel and come back in order to regain your status to be able to start working for that company again. So yeah.
Shiva has this question. This popped up multiple times today from YouTube, Emily. I may want your attention on this one though. What he's telling is that if today we are telling that the H-4 EADs can apply for the unemployment benefits, and right now, things are clear that it's not there in the public benefits program. If tomorrow the USCIS is going to say amend its public charge rule and include the unemployment benefits, will it cause any problems for the 485? How do you deal with the situation? What do you advise the clients?
Well, I think what we've seen till now with most immigration rules changes is they are prospective, meaning going forward. So they have to give you advance notice that they're making this change, and that change only takes effect going forward, not backwards. I mean, that's how the current public charge rule was put into place. It said that if you take public benefits after February 24th of 2020, then we will consider it. Those that took it before February 24th, it's not considered a public benefit. So I think that, yes, they could change their mind, but it will only be going forward. So if you take the benefit after they change their mind, then it would be an issue. I don't know if you have a different thought on that.
I agree with you on Emily and how they are doing, how they did it. But one caveat, Shiva, that I have to say is that it's called ex post facto law. What does that mean is that they cannot go back and change the things. That is not applicable in immigration. They have a legal authority to do it. But I still agree with what Emily has said, that they have been doing it only going forward, not going backwards. We saw the unlawful memo that has been issued for the student visa people. Even though that's been struck by the court, they went only going forward. They didn't went backward. When they try to cancel the EAD application for the people who are undocumentedly present in the country, we call them as dream kids. They only said that going forward 3 months from now, you're not going to be able to extend it. They didn't went right now all EADs are cannot work. They did not say that, only going forward. Now, that was struck down by the courts too, but I'm just telling how the government is intending when they are going forward. Even when this public charge benefit came in, as Emily pointed out, they went forward. So even though this administration may not be that immigrant friendly though, we haven't seen them implementing, violating the ex post facto law. We haven't seen them doing it. I mean, they haven't violated the basic principles of ex post facto law at this point of time. Is there a chance? I mean, we can't deny that there will never a chance, but under the conditions, that's a lot of money. If I were you, I would apply for the unemployment benefits, but take with a caution, Shiva. It's a very good question, Shiva. It's a very good question.
Shriner from YouTube has the H-1B 6th year expiring at the end of May, and currently the perm is in process, and of course premium processing is suspended. So he wants to know what are the best options at this time. I have several clients that are in that same situation where unfortunately the perm was not filed before they entered the 6th year, which really does limit your options if you can't get the I-140 approved in time before you hit your 6-year limit. So the first thing you want to look at is, have you actually recaptured all the time that you have available? If you haven't, your employer can file an extension to recapture any time you spent outside the U.S. to try to buy more time to allow for your perm to be approved. If you don't have any recapture time and your perm is still pending, know that the Department of Labor does not expedite perms. They are always first in, first out. There's no expediting, even if you're reaching your 6-year limit. So you have to hope that your perm gets approved in time so that you can file your I-140. But even just filing the I-140 is not enough. You have to get it approved, and there's no premium processing. Your I-140, your employer can try to expedite it. In the past, when they had suspended I-140 premium processing for some time, they did allow, if I remember correctly, those that had a max out issue on their H-1 to get expedited processing of the I-140. But if that is still not an option, your only option is to exit the country or file a change of status to B2. Or if your spouse is in H-1B status, you can file a change of status to H-4. Unfortunately, there's just not a lot of options for people in that situation.
JB has this question. Employer A has revoked his I-140 after it's been approved for 2 years. He is working for employer B right now. He is about to complete his 6 years. Can I get the extension with the old I-140? Here is the rule, JB. If there are 2 conditions that need to be met. One condition is that the I-140 must have been withdrawn after it's been approved for 180 days. Based on your comment, it's been withdrawn after 2 years. So that part you are saved. The second rule is that it must have been withdrawn after January of 2017. If it's been withdrawn in December of 2016, that rule is not, this rule of perpetual I-140 validity for you is not applicable. But if it's been withdrawn after January of 2017, and since you already said it's been withdrawn after 2 years, this I-140 is perpetually yours. In other words, employer B can use this I-140 approval, and if you want to move to extend beyond 6 years, if you want to move to employer C, you can still use employers A's I-140 approval. And also that if, for example, if you get laid off and you want to go to India or to your home country and you want to come back after 6 years or 5 years or 3 years, you can get the H-1B filed at any point of time and you can come back into the country without subject to any lottery system because you have an I-140 approved that has not been revoked for more than 180 days. It's been approved for, and it's not been revoked before January of 2017. That is perpetually yours, so you can get the H-1Bs, keep on extending and keep on coming back on the H-1B. Practically what I tell my fellow Indian nationals who came from India is that having an I-140 approved for more than 180 days and having been counted towards the H-1B number, this is practically the best thing that you can have. That is yours, and that nobody can take it right now from you.
Let's see here. Alan from Facebook is on STEM OPT and accidentally worked for a company that was not an E-Verify company. As soon as everyone realized it, employment was terminated. Now he wants to know if anything was violated during that time and whether he can start working for the company when the H-1B is approved starting on October 1st. So yes, it is a violation, both from the company side and from your side. If the H-1B is approved with a change of status, I would recommend traveling and getting the visa stamped and then coming back in order to start working for the company so that you don't make matters worse. And it's very clear once you re-enter on a new visa that any prior violation is cleared up so that it doesn't cause you a problem in the future.
Asim Khan has this interesting question. Can he use his grandfather's country of birth to get the priority date, since his grandfather is not born in China and India? Unfortunately, no, Asim. You can't choose your grandfather's country of birth. However, Asim, though, if your spouse is born outside India or China, though, that is usable. It doesn't have to be just you, the main applicant, even if your spouse is there. But no, not your grandfather. Not your grandfather, not your kid either. Just it's you or your spouse. That will be a cross-country chargeability, not your grandfather.
Kumar from YouTube says, myself and my husband are working in the same company for more than 5 years on H-1B. Husband's I-140 is approved and wants to know, do I still need to have a separate GC processing to get my own H-1B extension? So yes, if you are intending to stay on H-1B, you do have to have your own I-140 approval. You can't use your spouse's I-140 approval to extend your own H-1 beyond the 6-year limit. Your other option would be to change status to H-4 and work using the H-4 EAD, which you can obtain based on your spouse's I-140 approval.
Can a premium processing be filed for EB-1B? Right now, for all I-140 applications, there is no premium processing. You asked I think so what your question should be that, is premium processing normally allowed in EB-1B? The answer is yes, it's normally allowed in EB-1B, it's just not allowed right now. EB-1C, the premium processing is not allowed. It's been suspended for a long period of time, but for EB-1B, it's only suspended recently. Hopefully, when the COVID situation gets better, they should reintroduce the premium processing for EB-1B.
Vinothan from Facebook wants to know if an H-1B transfer is applicable after 60 days of unemployment, and how does unlawful presence work with that? So that's where the announcement that came from USCIS yesterday comes into play. Once you've crossed the 60 days of unemployment, if you then file a transfer, it's considered a late filing. And USCIS has a discretion to overlook a late filing of a transfer if you can prove that the delay in filing was due to extraordinary circumstances beyond your control and beyond the employer's control, and that the amount of the delay was commensurate with the circumstances. So in that situation, it's called a nunc-pro-tunc request for extension. You're filing a transfer and asking the government to overlook your time out of status and put you back in status and extend your H-1B with the new employer. You do have to have an I-94 that's valid, and you do have to be careful of the 180 days, which is where this is difficult because you may not get an answer within 180 days with no premium processing. So it may not be a good option to do. It may be better for you to file a change of status to B2 so that you can properly maintain a status rather than doing a late transfer.
Mehul has filed H-1B amendment, and now his old project got extended and his current project is not there. Can he withdraw and go back to the previous job without filing any application or causing any problem? The answer is yes, it will not. You can go back to the old project and you can withdraw the current amendment. It will not cause any problem. One interesting question is that Raj from YouTube has this question, is that if his H-1B does not get approved, can his wife, as a parent of the US citizen kid, because they do have a US citizen kid, can they stay in the country because the kid has to go to school? Based on that, can they legally stay in United States? Unfortunately, the answer is no. Just because your kid is a US citizen, you cannot anchor yourself into the country based on your kid unless your kid becomes 21 and files a green card. So, well, at that point of time, it's not a kid. So no, unfortunately, that's a very sad situation. There is no solution for it at this point of time. It doesn't look like any solution is going to come in the near future.
Krishna Mohan has noticed that for filing a B2 extension online, only the I-539 can be filed for one person, and there's no option to add a co-applicant, which is correct. So if you are filing for multiple people, you have the option of paying multiple filing fees to file online for each person individually, or you can file on paper with USCIS and pay one filing fee and add in the I-539 supplement.
A good question, Emily. That was a good question. Yes, good. You pointed out that you're right. That came out many times for us. Okay. When will the premium processing will come back? Question from Arvind. It's going to be very tough to guess with the COVID situation. It's tough. You may want to look to Dr. Fossey. He may be the rightful guy to judge when the things are going to get better. Definitely not us.
Selfmade from YouTube is about to file an H1 and H4 extension through their employer, but the spouse also was selected in the lottery and is planning to file their own H1B and wants to know if the spouse's H4 extension can be pending at the same time as their own H1B petition. And the answer is yes. Two applications can be pending for the same time, for the same person, for different statuses, because you qualify for both. If the current H4 is expiring before October 1st, know that you need the H4 extension to be approved in order for the change of status to H1 be approved. You can't have a gap because the H1B won't start until October 1st. But if the H4 is already valid beyond October 1st, then you can still get the H-1B change of status, and then you could withdraw the H-4 if it's still pending at that point because you wouldn't need it anymore.
Mr. Iyer from YouTube has this interesting question, is that looking back into 2008 recession, there was a movement in the backlogged things for the EB2 and EB3 and EB1 also, of course, and at the time EB1 was current. Is there a chance with this recession that you're expecting the backlog to be moved? It's a different scenario, Mr. Iyer, last time to this time. When in 2008 and 2009, there were a lot of leftover green cards that were available for Indian nationals. So how does this whole system work is that if there are 140,000 green cards available, only 7% can go to any particular country. If all the 140,000 are getting used up, any country that gets more than 7% will get cut off. Previously, from 1996 onwards to 2002, there was a rule that says that a country cannot get more than 7%, period. But they done away with the rule, saying that if there are extra green cards left, they can be given to the 7%. So between the 2002 and about 2012 or so, even up to about 2014, 2016, there were a lot of unused green cards by the other countries that were being given to the Indian nationals. So yes, there was a good movement at that point of time. Starting from about 2016, 2017, what we're noticing is that the leftover green cards are not there. So India is only limited with about 7% of the whole 140,000, which comes to be around 10,000 or so. In that, the families are included, only 5,000 families have been getting the green cards. So even though we may expect a recession, the demand for the employment base might go a little bit. The leftover green cards, we are not expecting significant improvement in the leftover because the rest of the world, the demand has gone up significantly too. So I am not expecting much movement in the employment-based green cards though. Yes, there may be movement of 2-3 months, but can we expect the movement to go years, every month, every other month? I'm not expecting though at this point of time. Hopefully so, Mr. Iyer. I go wrong, then you're lucky then.
All right, I think we have time for one last question. We'll take this one from Venkat from Facebook. He wants to know if an employee has a valid B2 visa in their passport, but is laid off while working in H-1B, will that B2 visa allow them to stay in the United States? The answer is no. You would actually have to file a change of status from H-1B to B2 in order for that to work. The B2 visa that's in your passport only becomes active if you exit the country and come back in B2 status. But if you can't exit right now because you don't have a place to go to, that's not really an option. So filing the change of status, the I-539 application, is the best way to get to B2 status if you need that.
We want you to continue coming to our YouTube and Facebook. Please, there are a lot of misinformation that are getting circulated in the press. Please log on to Immigration Girl blog, which Emily manages, and also RN Law Group news section, and you can subscribe to RN Law Group news section. We are posting the current articles, what you need. And don't forget that we have done a 50% reduction in our fees, 50% reduction in our consulting fees for all the lawyers in our office until April 30th because of the COVID situation. Yes, some of our lawyers may not be working from the office, but they are working from their homes. So if you please don't hesitate to make an appointment and seek any legal help you need at this point of time.
All right, thanks so much for joining us today. We'll see you next week.
Thank you guys for coming in.